This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, I'd like to speak about an assault and battery condition that limits the amount covered rather than excludes the entire risk of loss by an assault and battery. Great American E&S Insurance Company obtained a trial court judgment that it only was obligated to provide coverage up to a limit of $25,000 under a policy of insurance issued to the defendant, Commack Hotel, LLC, doing business as Howard Johnson, in an underlying action where Stanley Earl Davis, Jr. was stabbed to death while on the hotel property. In Great American E&S versus Commack Hotel et al. And Stanley Davis, a December 7, 2022 decision of the Supreme Court of New York's Second Department, that appellate court resolved the dispute. Stanley Davis appealed from an order of the Supreme Court, Suffolk County, David T. Reilly, Justice, the trial court, dated October 21, 2019. The order granted the plaintiff's motion for summary judgment on the complaint, and the plaintiff appealed. On November 13, 2010, the defendant, Stanley Davis's son, was stabbed to death by Carlos Rodriguez during a party in a room at a hotel owned by Commack Hotel, LLC, doing business as Howard Johnson's. In an underlying action entitled Davis v. Commack, the defendant, Stanley Davis, as administrator of the deceased estate, appealed the order. Following that determination, the plaintiff commenced this action for a judgment declaring that it owes no obligation to indemnify Howard Johnson in excess of $25,000 under the assault and battery limits of liability endorsement of its insurance policy, and moved for summary judgment on the complaint. In an order dated October 21, 2019, the Supreme Court, the trial court, granted the plaintiff's motion, finding that the plaintiff's obligation to pay damages on behalf of Howard Johnson in connection with the underlying action was limited to the assault and battery sublimit set forth in the endorsement. The court, recognizing the duty to defend, advised that the duty is triggered whenever the allegations of a complaint liberally construed suggest a reasonable possibility of coverage or the insurer's actual knowledge of facts establishing a reasonable possibility of coverage. An insurer carrier can be relieved of its duty to defend if it establishes as a matter of law that there is no possible factual or legal basis on which it might eventually be obligated to indemnify its insured under any policy provision. Policy exclusions are subject to strict construction and must be read narrowly, and any ambiguities in the insurance policy are to be construed against the insurer. However, unambiguous provisions of insurance contracts will be given their plain and ordinary meaning. An exclusion for all assault and or battery applies if no cause of action would exist but for the assault and or battery. The appellate court determined that negligence claims arising from an assault and battery also fall under assault and battery endorsements that limit coverage for damages. In this case, the plaintiff established its prima facie entitlement to judgment as a matter of law by demonstrating that the assault and battery endorsement's limitation is applicable to the claims asserted against Howard Johnson by Davis in the underlying action. Accordingly, the trial court, the Supreme Court, properly granted the plaintiff's motion for summary judgment on the complaint, which sought a judgment declaring that the plaintiff is only obligated to provide insurance coverage up to a limit of $25,000 under the policy in the underlying action. In my opinion and experience, most insurers of public properties will exclude defense or indemnity for an assault or battery. Some attempting to provide better coverage will insure against claims of assault and or battery, but limit the amount the insurer is willing to pay to indemnify its insured. Commack Hotel, LLC, doing business as Howard Johnson, obtained a policy with a $25,000 assault and battery limit. The appellate court agreed that the limitation was appropriate and enforceable. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and will receive notice of the blog postings, which are usually one every day of the working days or 5 days a week, sometimes more than one in those 5 days. You can also subscribe to the videos on rumble.com and youtube.com, and I'd appreciate it if you click on the like button on YouTube or the rumble button on rumble.com if you watch on that service. If you found this video to be interesting or useful to you, please tell your colleagues so that they can also subscribe to the blog and the videos. Thank you for your attention.